I'm Carmise Graves, and I practice family law in the Washington, D.C. area.
One of the questions we have to think about, like say if you're married and you're dealing with your house and you own it together, the question is, well, we have an asset that we need to deal with.
Sunset, they just abandoned me and come back. They've been gone. They've been gone. They've been gone. They ain't seen nobody, so I guess it's over. Like this, man, you just can't leave. Not true. Okay, that's what they call me. Are there people throughout history that despite whatever circumstances, they did what they wanted to do?
Hello, welcome. Act like I'm at Caroline Kitchen. This is attorney Carmise T. Graves. I practice estate planning and family law in the Washington, D.C. and Maryland area. Today, we are continuing our series on legacy gifting, estate planning. I get a lot of calls about estate planning, a lot of questions. They're typically the basic questions. So at the last meeting that we had regarding ancillary documents that you must have in a basic estate plan, I said I would follow up and do this video that will go through one of the primary questions I get. People want to know, what's the difference between a last will and testament and a revocable living trust? I get that question a lot. So I figured it would be helpful to break it down for you in a video, because typically when you do a consultation, you guys are asking a lot of questions and you get fire hosed with information and it's a bit overwhelming. So this video will be for the general public. Also, if you consult with me, you'll get it before and after, and be able to review it and take some time with it, because the topics in estate planning are not common knowledge. I feel like some other areas of the law, maybe divorce, even if they're missed and they're not exactly right, it's something that you have some general understanding about. But when it comes to estate planning, it can be all new, so the information can be quite overwhelming. So I figured, let's just break it down, okay? And then that will enable you to make the most out of your consultation with me. You would have had this video already, and then we can get into the designing of the plan. And let's start there. The main purpose for doing estate planning is that you're able to minimize conflict. You're able to ensure that who you would like to receive certain gifts and bequests, get them when you want, how you want, under the circumstance you dictate, depending on the instrument that you choose. So let's jump right in. I don't want the video to be too long. So first off, the last will and testament. This is a basic document that it is designed to augment the default rules of intestacy. So if you have no plan in place and do no estate planning, no problem. The state has done it for you. And they are called the rules of intestacy. So you can do a last will and testament to augment those rules, kind of like how there are default rules to divorce and you do a prenuptial agreement. A prenuptial agreement is an estate planning document designed to change those default rules. So let's talk about what some of those default rules might be. Say, for instance, you don't want any of your family members to be the executor of your estate. In the default rules of intestacy, those blood relatives would have priority. So once you pass away, if you have no estate plan in place, they get your death certificate and they run down to the register of wills, open that petition, establish the relationship. And unless someone comes and contests it, they will be the executor of your estate, or more technically correct, the personal representative. The executor is who you name in your last will and testament. So again, the last will and testament are simple. It's your legal instructions, designating who your executor is going to be. It's giving legal instructions as to how you like your estate to be conveyed to your heirs. that augment the rules of intestacy. That's what it does. Now, what it does not do, it does not avoid the probate process. Now, what is that? I guess I have to get into that a little bit. The probate process is the legal administrative process whereby the I guess the court has either they're going to go by the rules of intestacy or they're going to follow your legal instructions to make sure the person that they have authorized as your personal representative follows your legal instructions or follows the default rules. So a personal representative receives letters of administration. There's a lot of rules to probate. You have to do an inventory of your assets. You have to publish a notice in the newspaper. You have to leave it open for a certain amount of months for any creditor claims. It's just under the oversight of the court, okay? The court's involved with the administration of your estate and your affairs. Now, so it's a very public process. If you're a private person, that's one of the reasons why you would want to avoid probate, right? If you don't want to have to list, who your next of kin are, what your probate and non-probate assets were. There's just a lot of public information because it's a public record and anybody can go into the public records and look up your estate and see what happened. It's public record. So, and it's tedious. There's a lot of accounting involved. Okay. So, and your people are grieving. So it's something I feel that if you think forward and you want to be forward thinking, you may want to avoid some of these requirements. Another requirement that you will subject your personal representative to is a bond. Even if you have a waiver of bond, they're going to still require that they get a bond, even if they're the sole heir, meaning they're going to have credit worthiness, okay? Because to get a bond, they're going to check the credit. They can't have prior convictions. So that also can interfere with who you designate to be the executor and or personal representative of your estate. Make sure they're credit worthy, okay? Because they could be managing assets for creditors. So we don't know what the creditor claims are. So the court says, listen, if you are managing and you have a fiduciary responsibility, we're going to need some insurance should you mess this up to make sure creditors and or other beneficiaries are made whole. So that is another requirement of the court. So you're subjecting the administration of your estate to the court process and also requiring your personal representative to do a lot of work. And this is what comes along with the last will and testament. So then what is the answer to that? The answer to that is the revocable living trust. So people say, well, what's that? What's that? This is a legal document. And the best way that I can describe it is it's similar to forming a company, right? Think about forming an LLC. This company that's specifically designated to handle and manage your assets. You set up the company, you establish its name, you are the primary officer of this company. You're called the trustee. You're the settlor, you're the trustee. You kind of set the operating agreement or bylaws or the instructions on how this trust will operate, what kind of assets will be held in the trust, when it's time, where those assets will go, who will receive them, who will be the beneficiaries. And the key thing, you will also designate who the successor trustees are. You're able to change trustees. You're able to make changes to your revocable living trust. That's why it's called revocable, because you can take assets in, you can, uh, move them around, you can change what's going on. You're managing this company. You are the primary manager of this company until you pass away. When you pass away, the settlor of the trust instructions are locked. The successor trustees just follow your lead and your instruction. Now, this trust avoids probate. It's a private process, okay? It's not subjected to the administrative process of the court. And that to me is the hugest benefit. Your loved ones are grieving, they're missing you, they're going through a hard time. And I think it's, if you can make the effort to make that process a more seamless process during their time of grief, it would be better. One of the things now they says, well, explain to me how this works. Now, the reason why assets go through probate is because when you pass away, when I pass away, you pass away, we all pass away, you can still own assets. Those assets still are titled in your name. Let me give you an example. So, say you pass away and you own a house, right? And the house is solely titled in your name, okay? And when you pass away, you have left in your will, say in this example, you have a will, and you have conveyed this asset to your daughter, okay? Now, what's going to happen is whoever the executor is, they're going to need to get permission from the court. And the probate process is them stepping into your shoes one last time to sign off on the deed according to your instructions to convey the property to your daughter. Because, as you know, with deeds, you need the grantor and the grantee. And you've passed away, so you no longer can sign. So this person has been designated to act legally as you for this particular purpose to transfer your last assets according to your instructions or according to the default rules if you've done no planning. That's what probate is really all about. So this person, whoever they are, according to your will, they can sign that deed over from you to your daughter. That's generally what's happening. You have to do that with cars. You have to do that with any account, any asset that has a title and or deed. There are assets that are non-probate assets that are beneficiary designations, and that process takes care of it. The trust inherently has that same power, like that beneficiary designation within the document itself. It is imbued with the legal authority to empower the successor trustees that through that document, you can transfer the assets. So instead of having to go to petition the court to get the letters of administration and all that rigmarole, you get to simply present the trust to an attorney like myself with the death certificate, and we're able to use that document and the authority imbued within it to execute that deed. So look at the difference in the process. This is what you get to do, whether there's bank accounts, whether there's boats, there's cars, there's always a trust officer someplace that can manage the assets and has the wherewithal to facilitate your transaction quietly, discreetly, and quickly and efficiently. Okay. So that is the nuts and bolts of what that trust can do. Other things that it can do that other that the will can't do is that you can really get savvy in terms of when you want assets to be released. Here is a prime example. Say you want to get insurance, an insurance policy for your youngster, right? And the insurance policy is $1 million. Okay, so it's $500,000. So you get $500,000 policy on your life, and you want to make sure that it's available for your kids. And say, you have one child, and the child maybe right now is 12 years old. Okay, and say by life, who knows when we're going to pass, but say when you pass, your child is now reached the age of, we're going to give two examples here. Let's say they have not reached the age of majority and you've gotten this insurance policy. Well, that's going to cause a problem. And I want you guys to make a note of this. Minors cannot be beneficiaries. Minors, if your kids are under the age of 18 when you're doing your estate planning, they should not be named as beneficiaries, because what's going to happen is, under the law, they cannot legally take that asset until they reach the age of majority. And then you're going to have to go to court and do a whole bunch of filings with the court and pleadings with the court and saying why it was the intent and the best interest. But they may say, park that money in an account until this child reaches the age of 18. And you may have intended that the money be available to take care of them. So maybe there's a guardian and you have this insurance money and you have this set aside, and like, look, you can be the guardian, but Anything my child needs, I have money here for my child to go to private school, to do sports, to do whatever they need, to take trips to Europe and back, to Ghana and back, wherever the child wants to go, there's money. But if you put them down as the beneficiary, that's not going to happen just like that. That money could be sitting there. Say if that child, an example, is 13, 14, that money's going to be sitting there for 4 years or so until the child becomes of legal age to take the asset. That's not what you want to do. So that's a freebie here. Do not have minor children as beneficiaries on any legal documents. So, but let's run it and say that they have reached the age of majority. Say they're, 25 years old, like we started in the example. Is it your intent that your 25-year-old is going to get a $500,000 check? Probably not. You probably would want to say, wait a minute, like a parent would. I have some money set aside, but let's talk about what it's for. It's not just for you to buy expensive cars and blow the money in Vegas. I want you to do, make sure you pay your, for your college education. Make sure that you take care of ABC 1, 2, 3. Maybe you want the money to be designated for investments in real estate and or a business. That's what the trust can do. That's what the will is not going to do. That's what an insurance policy is not going to do. But that is what a revocable living trust gives you the flexibility to opine. You can do that for a surviving spouse. Like, hey, I want this money not to, just fly out of here. I want it to be used for health, education, maintenance, and support. We call that HEMS, okay? So it gives you some creativity as to the timing and the uses of money that you leave to your heirs. And that's one of the main reasons people like revocable living trusts because of that flexibility, unlike the will. Okay. So I think that kind of gives you guys some nuts and bolts in terms of what it is. Final question that I get a lot of is how do you actually get assets into the trust? Now, this is called funding the trust because it is pretty much a bunch of paper. So I'm like, how actually am I going to get my house into this 65-page document? And simply, it is a title transfer. So we're transferring titles on bank accounts. We're executing new deeds that come from your personal name and into the name of the trust. And this is why and how you avoid probate, because the trust is a living, breathing thing that does not pass away like humans. So it does not go through the probate process. You and your loved ones avoid probate because ostensibly when you pass away, there are no major assets titled to you in your name, so you have nothing to probate. Okay. And filing probate is not always necessary. Okay. They have to do an analysis. It's not by default, you need it. And you can see people who have taken care of their estates when you hear about celebrities and famous folks passing away, and all you hear is that they passed away peaceably in their house, and you don't hear anything like the James Brown mess or print the state of Prince. You don't hear anything because they took care of it. And that's kind of how you want this to go, as smoothly and seamlessly as possible. So I'm going to leave it here because even though that I know I'm talking fast because I don't want the video to be too long, and I want you to have something that you can review and think about so that when you do book your consultation, we can talk about your dreams and goals for estate planning and then not get too marked down into the technicalities, but you have enough information to feel informed about what you're doing and why you're doing it. And again, I'll leave you with this. For estate planning, I think one of the major things that we need to consider, and I want someone to do a study on this, it must be a feature of being a human being because the amount of vitriol and conflict that comes up as a result of distributing somebody else's remains is amazing. It must be an inherent survival mechanism of the kind of animal side of human beings, because if they are not emotionally mature or savvy, or I don't know, they just turn into like animalistic hyenas. and they will tear anybody up. It feels like they're dealing, I think when someone passes away, you're confronted with your own mortality, right? It's when you realize, man, as much as I'd like to believe it, this is a temporary journey, and that blows, and it's scary, it's confronting. And this is the part that I don't really have any data. I just experience it as an estate planning attorney. After that grief and that kind of confronting experience that we are mortal beings and this is a temporary journey, then it becomes like a matter of survival. Even if people are wealthy, even if they got their own stuff, they own money in the bank, they feel like you should leave something for them to help them carry on, and you've kind of left them, like you've left them behind here on earth to manage for themselves, and it's every man for themselves. I've seen families torn apart as a result of, and I know a lot of you have your own stories because it's pretty common. So really think about keeping your family together. You know who don't really get along with who. You know who's a little bit off emotionally. You know who might lose it and try and jump on the casket in the grave with you. Those are the people that usually run through the house and take mama's furs and take this and take that. I'm taking over. And they're using maybe the fact that they're the eldest. I got rank. I'm older than all y'all, and y'all gonna do what I say. You may not want your eldest child to dictate what is going to happen with your estate to the others. And this is the key reason for anything else to keep your family in order. Please do your estate planning. Please. If you've done a great job with accumulating assets, you do owe it to others to make sure you take care of how they are distributed amongst your beneficiaries. Upon your passing, it will instill peace and order. So that's it. I'm going to leave it right here with you. I hope you guys are doing really well. And I'm going to continue this series because I'm so proud of all the progress that I'm seeing in our community, and that we are really interested in this legacy gifting and estate planning. So until next time, thanks so much for tuning in. And I hope you guys are doing well. And I will check in with you soon. Okay.
I'm Carmise Graves, and I practice family law in the Washington, D.C. area.
One of the questions we have to think about, like say if you're married and you're dealing with your house and you own it together, the question is, well, we have an asset that we need to deal with.